Howdy, my name is Carl Dore. Welcome to the Trends and Traps for 2019 in the oil and gas services industry related to how to analyze and review and see exposure in the risk analysis world. That's what we do as attorneys. We're constantly evaluating and working with risk assessments between the credit management world and the general counsel's departments. How do those fit? How do they react? How do they handle their contracts, their reviews, their exposure? It's more than just what is the operational issues on a frac job. I'm stuck on the well and I can't get off safely and the guy's out of money. It's bigger and stranger today than that. But I think you're going to find it interesting. We have segments of virtually all the topics we could come up with that would fit your world and your interest today. Everything from how to use a petroleum engineer to analyze the complexities of the customer operator, to what do you do after a bankruptcy and they're trying to claw back and take your money back from you. I hope you enjoy it. Get ready. Thanks.
McKay. Now, Zach and I are both bankruptcy lawyers. We do little different things. I represent Chevron in the PG&E case and companies in Japan, Qatar, Saudi Arabia, and places like Singapore, fun places to go to be sure. And I've worked in some of the interesting, weird, double black diamond areas of bankruptcy law. Now, Zach is a bankruptcy expert who has done fantastic work in the bankruptcy world. He's done a lot of work in the Houston courts with great judges and getting good money for his clients. And if I had to do that well, I'd call Zach, just so you know. So let me get started real quick. We've divided our time. Zach, do you have anything to say other than you're an awesome lawyer? Okay, he's an awesome lawyer. Thank you. Let me get started with the very basics. Bankruptcy is not for dilettantes. The bankruptcy rules are different from the federal rules of civil procedure. They're different from the Texas rules of civil procedure. The law is different, and you don't have to do anything wrong to get sued. You can literally be sued for doing exactly what you are ethically and morally supposed to do in a capitalist society. Real quick, raise your hand if you have represented or had worked with a client, rather a company that has been sued for a preference. All right. So some of you, raise your hand if you don't know what a preference is. Okay, good. Zach, take it away.
So basically, just on a general level, a preferential transfer, and we're going to get into the more complex statutory definition in just a few minutes, but a preferential transfer is generally a transfer that you receive from a bankruptcy debtor within the 90-day period prior to them filing bankruptcy. So we try to break this up into steps. You get a notice that your customer filed bankruptcy. What do? First, you check your exposure. Because a lot of times when one of our customers files bankruptcy, we have a tendency to immediately get infatuated with navigating through the bankruptcy process. And that is a very important goal to have. However, sometimes we fail to look backwards and to look at the exposure of the payments that we received in the 90 days prior to the filing. So we look back 90 days. Any payment you received could be clawed back by a bankruptcy trustee or the debtor, and it could be 2 years later. Now, the first thing to know is you did nothing wrong by getting one of these payments. In fact, as credit professionals in this room, our job is to get paid, right? So we did our job. You got this payment, and it's not your fault that the debtor filed within 90 days. It's not your job to make sure that they're not filing bankruptcy within 90 days when you take a big payment like that. The Bankruptcy Code presumes, often incorrectly, that if you receive one of these payments, you were preferred over other similarly situated creditors. The idea being that you were paid because they like you more, or you sent them a threatening email, or you were about to file liens. You got the $400,000 or whatever you received in lieu of other similarly situated creditors, and it should have been split up equally. So that's the theory behind it. Once again, the debtor or the trustee can wait 2 years. Generally, there's another way to calculate that, but generally it's 2 years after the bankruptcy has been filed, which is a long time, right? The jurisdiction where you get sued is wherever the debtor filed bankruptcy. Could be New York, could be Delaware. Lately, we've been seeing more and more in Houston, which is a good thing. Check your exposure immediately so you know. You don't have to talk to your CFO 2 years down the line and say, oh, by the way, we have $2 million of preference exposure. Sorry for not telling you. Talk to an attorney, okay? Because this is a very complex area. Not only is the statute complex, but the defenses you have to prove up are very complex. But there are defenses and there are best practices that you can use that will help set you up successfully to defend these claims later. So Hugh, why don't you talk about the preference statute?
Sure. The key here is that back in the days of Shakespeare, they had courts of chancery, where the chancery court, run by the chancellor, would find that a creditor, this is where you could torture people to get them to pay. A creditor had caught, I'm not kidding, they literally put hot coals on their feet. So that you would catch and imprison a debtor, torture him, he would pay you, and then the next guy to capture him would see his blistered feet and say, darn numbit, now I can't get my money. So back in the 16th century, they decided that they would return that money into the court and then redistribute it out equally, so the creditor that acted in an unusual manner would have to pay the money back. So this has been codified originally in 1898 and then in 1978 into a bankruptcy code provision. And this exists in a lot of laws, not just the United States. A transfer. And each one of these elements is on the burden of proof, is on the trustee, is on the person who's suing you or threatening to sue you. A transfer of an interest of the debtor in property to or for the benefit of a creditor for or an account of an antecedent debt made while the debtor was insolvent, made within 90 days before filing the petition or between 90 days and 1 year of the petition's filing, if such creditor was an insider, and that enables a creditor to receive more than it would otherwise in a hypothetical Chapter 7 case. All right, guys, get the materials online. If they get them from Carl or the event sponsor, this is the checklist I'm going to run through is the best way to defend yourself against a preference. It's not by defending yourself against a preference. It's by saying one never happened in the first place. Okay? Each one of these elements you can attack and put the plaintiff to a burden of proof. I'm waiting on the thingy here. We used to call these a clicker, but they don't click anymore. Okay, there we go. So, the first, did I actually receive a transfer? Which, in the bankruptcy code, doesn't mean money was paid to me. It could mean I put a lien on property. All right? It could mean an involuntary action, one that happened automatically, or because a state court issued a writ of sequestration. It doesn't matter that you got a court order. It doesn't matter that it was automatic. It doesn't matter you had a computer program with blockchain that was set up to do it automatically, and no one meant for it to happen. It just happened. It doesn't care. If the lien goes on, if the transfer is a retention of a security interest, or any direct or indirect, absolute or conditional transferring property, that's a transfer. So, how do you defend against such a broad definition of transfer? It means the debtor has acquired rights in property transfer. Now, what about when you have a letter of credit? That's not a transfer from the debtor. That's from a bank. And the debtor has no right to call the bank up and say, pay me the letter of credit. That existed for you. How about an insurance policy? Well, it depends on the policy. Some insurance policies pay the debtor, like a D&O policy for indemnity, directors and officers liability, but most casualty policies and other kinds of policies would be payable if it's paid to you for some reason. Let's say there was a car wreck or something like that, and you got the money because of a wreck from the debtor's car from the insurance company. That would be not a transfer. The magic conduit, magic moment, mere conduit. There was a case called Coral Petroleum where money came in to a company, all the money, $40 million, went into this debtor in the morning because it came from an offshore account. The debtor had an onshore account. And then about an hour later, it went out to the to the creditor, to the purchaser. Is that a transfer of debtor's interest property? The Fifth Circuit said no. Really, in that when it's a tight transfer like that, it's not a transfer. Because the debtor couldn't have called up the bank sometime during this wire transfer and diverted the money. He couldn't have used it. Earmarking. This is a really good one in the oil and gas field. I use this one a lot. You know, or in construction. Either way, you've got checks that come in and the checks say this is for this purpose. You may not use it otherwise. That's not a transfer because it's not really the debtor's money. The debtor's just holding it in trust. He's going to pay it on to you. So the operator gets money in trust, and I've used earmarking a lot with our arguments about what an operator can and cannot do. It pays off. Constructive trust. If the debtor did something wrong, he stole that money and gave it to you. Well, it was never the debtor's money. He stole it. Pensions, IRAs, etc. I'm on clicker. There we go. All right. So within 90 days, its property was delivered. The argument of within 90 days applies to, it's a year for insiders, just so you know. And what is an insider? The United States Supreme Court has said you know it when you see it. An officer, a family member of an officer, someone who is in a, how do I put this tactfully, in a bedroom relationship with an officer counts. People who are large shareholders count. Subsidiaries, affiliates, those count as insiders. So you can go back 90 days or 1 year for an insider. A check is considered transferred when it's cleared, not when you get it, not when you take it to the bank, or when it is cleared. The Supreme Court has ruled on that. The time of the lien is the date perfected if it's perfected within 30 days of the bankruptcy. If it's perfected, 30 days of the lien being granted. If it is perfected after 30 days, it's the date perfected. In other words, if they give you a security agreement and you wait to file the UCC-1 31 days, the transfer is the date you file the UCC-1. If you file that UCC-1 29 days later, it's the date you had the security agreement. So it's a safe harbor provision. And if it's not perfected, you didn't really get the transfer. For reasons that I'm not going to go into. Bankruptcy law doesn't care about unperfected transfers. You're basically not a lien holder if you don't have a perfected lien. While insolvent, there's a presumption of insolvency within 90 days built into the statute. People presume that the debtor is insolvent, but that doesn't mean that they are. And I can't tell you the number of times I've looked at a debtor's schedule, sworn, filed under penalty of perjury, where the debtor says, for whatever other reason, their assets exceed their liabilities. Well, okay, use that. Use that as a defense on an antecedent debt. Now, an antecedent is a trick. You would think it means something like an old debt. It doesn't. It means not simultaneous. Anything that is not simultaneous. So it excludes COD, cash in advance, and contemporaneous sales. And the debt exists when a debtor first has an obligation to pay. A frequent trick is, let's say you send the invoice, you walk the invoice to the other guy's building and hand him the invoice, or her, and they hand you a check. And you say, that's contemporaneous exchange, that's simultaneous. No, because when you delivered the goods or the services, that's when the debtor became obligated to pay, not when you delivered the invoices. Guess what? You can still make the argument. You can still say, I walked over and it was a contemporaneous exchange. Just because you're going to lose doesn't mean you don't make that argument to negotiate a stronger position and put them on their heels. Uh-oh.
Skip one.
Well, this clicker is old enough to be called a clicker. All right. To or for the benefit of a creditor. The creditor must have control over the property. So the same thing that I said about a transfer works for the creditor. You can say, I accepted this in trust. I'm a fiduciary for X. My master services agreement says this isn't mine, it's theirs. And go talk to them. I didn't receive this transfer. Now, if you're not a creditor at all, you have other problems. Why were you paid the money? Was it a fraudulent transfer? Did you steal it? What were you doing with that money? So you're probably going to be considered a creditor. Now this is one of the best ones this is the best one for oil field services, or for any other oil field business, or even construction. Are you fully secured and perfected and in the money? Well, you say, I didn't file a lien, but I would have, right? I would have filed a lien, but for the fact that I got this check. That's why you paid me on the 120th day, right? Because you know in 180 days I was going to file a lien. I was going to call Carl. Carl will get that lien filed very quickly. It's really good at it. Would you have been paid as an administrative expense? Okay. In big Chapter 11s, nasty, big, ugly Chapter 11s, they have critical vendors that get paid as administrative expenses because they're so important. You're the sole source supplier of this widget that we need to drill this well. No one else on the planet makes the widget, and if we don't pay you, we don't get any more widgets. We don't have any more widgets. We can't drill the well. Okay? So if you're already a critical vendor and you would have been paid current anyway under the court order, then you're off the hook there. Would you have a statutory right to be paid in a Chapter 7? Are you an Indian tribe? Raise your hand if you're an Indian. Just kidding. Indian tribe's not statutory. Domestic support obligations do, though. So if you're getting paid from a child custody dispute or something like that. Would you have imposed a constructive trust, like an interest of property? In other words, could you argue that the payment was not a settlement of a debt, but a settlement of something much more serious, like a theft or a fraud? You can argue that you were actually paid back yours. It wasn't a payment of a debt. Would you have recouped set-off or had the contract assumed? Set-off's a bit problematic, and generally speaking, I'm not going to get into set-off issues, but if it's an executory contract, a long-term contract to deal over a long term, then, and that they said they were going to assume that contract. In other words, the contract rides through bankruptcy, and there's no bankruptcy at all. Well, who cares if it's not a preference, it's just continuing through on this contract that rode through bankruptcy. It's a good defense. All right. There.
Right.
That's you, Zach.
There we go. Okay, so those are all ways that Hugh just mentioned to poke holes in what the trustee has to prove up. Those are all the elements the trustee needs to prove in order for them to meet their burden and say, yes, there was a transfer here that was avoidable. And if you could do that, we don't have to worry about any of these defenses, and that's why Hugh mentioned that it's so great to be able to poke holes in some of those things. But very often we find that, yes, these transfers occurred, but they're going to, more often than not, have a fairly clear path to prove up those elements. And so the preference statute gives us certain defenses that we utilize every single time that will almost certainly lower or eliminate the exposure here. Now, these are all situations. We're going to go into each of these in detail, but generally, if any of these situations have occurred, you need to tell your attorney that, because we think we were on the path to prove up one of these four defenses. So first, contemporaneous exchange for new value. That's a simultaneous transfer. Yes, we did receive a transfer, and yes, it may or may not meet all of those elements of a preference, but we gave something to the trustee, or to the debtor, at the same time. Now, there are some other intricate details that you have to prove up. We're going to go into that in a minute, but if that occurred, you need to tell your attorney, because we're on to something. Another form of new value is subsequent new value. Now, this is something that lives and breathes in the 90 days only. So if you received a payment in the 90 days, and it's a preferential transfer, or an alleged preferential transfer, and then you did work after you received that payment, still within the 90 days, in other words, you were working with these guys all the way up until when they filed. Well, that is a statutory dollar-for-dollar reduction of your preference exposure. That's the easiest one to prove up. It's a math problem. We'll go into that also. Now, there are two different kinds of ordinary course of business analysis that the Bankruptcy Code allows. Before 2005, in the VAT CPA amendments that Congress passed, you used to have to prove both of these up, and it was very difficult. But now, it changed from an and to an or. You can prove up this one or this one. So the first one is a historical analysis. Yes, we did receive a transfer, but the payments were made around the same time and in the same manner as previous historical payments made between you and that debtor. Those two parties are the ones you look at. Now the last one, ordinary course of business industry analysis. It's called objective or industry analysis. I call it industry analysis. It's easier to remind yourself. We don't look at these two companies anymore. We take a step back and we look at what was going on in the industry at that time. So yes, we did receive a transfer, but the payment was made in a way that was ordinary in the industry at the time that payment was made. And so one of the interesting things about this defense is, especially in our industry, is in 2014, 2015 during the downturn, you had nearly unlimited leeway to argue what was normal in the industry at that time. We're going to get into that. So real quick, we're going to go through each of these. Contemporaneous exchange for new value. Contemporaneous exchange for new value that was in fact contemporaneous. In other words, it has to have happened at the same time. And both parties, well, substantially at the same time. And both parties had to intend that it was supposed to happen at the same time. So as a few examples, payment, reduced loan, covenant, restrictions simultaneously. Payment today in exchange for more credit today. COD, or settling a lawsuit. Those are each things that you're providing value to the debtor. You're releasing a lawsuit obligation, you're releasing a judgment, whatever, in exchange for a payment that's simultaneous, and it was intended to be simultaneous. So there is a definition of new value. It's not just money. It's money's worth of goods, services, and a couple of other things. Now this is only, let's see, yes, or release by a transferee of property previously transferred to such transferee in a transaction that is neither void nor voidable.
Can I speak? Just
Go ahead.
very- Okay, there's cases out there where people have had Vinny go over and say, Vinny's going to break your legs if you don't pay.
Right.
And then I paid, and therefore there was new value because I have legs, right? The guy has legs, that's value. You were not going to have legs when Vinny got done with you, right? Well, unfortunately, the Supreme Court has said, no, that is non-economic new value. Having legs, not being defamed, not being extorted, not having your name put on a billboard as a deadbeat, those are not economic new value. So that new value needs to be actually something like money. All right, sorry.
And it's also only to the extent of the new value, so the value must be comparable. And again, we have, see, these are all things that now we have to prove up as a defendant. And the intent portion, remember we have to prove up that it was in fact substantially contemporaneous, and that both parties intended for that to be so. Intent, we have to prove up it's a fact question. It's difficult sometimes. Okay, another one. This is the easy one, right? This is subsequent new value. This is a math question. We love these, okay? Basically, well, it's definitely the easiest one to prove up to a trustee. It's, all these other ones are more of an art. I think this one is a science. You look at the numbers. Now, there are some intricacies. So basically, for example, in the 90-day period, you delivered this doesn't have to be in the 90 days, but let's say you delivered $10,000 worth of goods. You received a payment of $4,000 in the 90 days. Subsequent to that, you delivered another $2,000 worth of goods, okay? So your preference exposure, according to this defense, is lowered dollar for dollar by the new value you provided, the $2,000 of goods. So you had a $4,000 exposure, you delivered $2,000 more in the preference period, and now your preference exposure is reduced to $2,000. Delivery of the goods creates a duty to pay, not the invoices. Now we'll argue whatever helps us the most, but generally that is the rule. Now there is a circuit, so if we're going to see, this is where it gets a little complicated. There are cases and courts out there that have argued, okay, what if this debtor was on top of its payables, and when you delivered that $2,000 worth of goods, you then got a payment for that $2,000 worth of goods. Is that still new value because they paid you for it? Circuit split. In Texas, it is new value, which is good. In Delaware, there are cases which have allowed it. But
the Third Circuit has ruled that they're going now with the Fifth Circuit with most of the people on the planet, but there are still 3 circuits out there that hold that you get this ridiculous paid new value.
Right.
Oh, I shouldn't say ridiculous. I mean, guys, the guy who makes this argument drives 3 Ferraris. He's got money. He's doing great with this argument.
And that's generally a rundown of the 2 different types of new value you can argue. That's your burden of proof. Hugh, why don't you tell them a little bit about the ordinary course of business defenses?
Sure. Okay. True story, I was in Delaware in January trying to explain oil and gas to Delaware judges and lawyers. And that was interesting. By the way, they say they understand Texas oil and gas law and oilfield services law. Remember, the debtor's location of filing has nothing to do with where they ever did business, okay?
Or where their creditors are.
Right, and they might not even be where the parent company's incorporated. There's a case where someone created a subsidiary and filed in Alaska, and don't think that wasn't to harass the creditors, right? I'm surprised they didn't choose Guam. It's more remote, or the Marshall Islands or whatever. But you can file wherever your parent is, wherever any subsidiary is, or where they are incorporated. So one of the problems with the ordinary course of defense is I have had mixed results in oil and gas cases, depending on when I am in Houston, Texas, telling a judge that people getting paid in 120 days is ordinary course, and the judge nods his head and says, of course it is. I grew up here. I know that. And a judge in Delaware who says, you mean they didn't pay 15 days after invoicing? That's crazy. So understand this issue. I'm going to, by the way, tell you the cheapest way to hire me, besides free, is actually what they did in one of these cases. So I have been on both sides. I have filed 600 preference cases for one client, 1,500 preference cases for another client. I know it can be a bit of a shakedown sometimes. Sometimes, though, because when I file them, they're never a shakedown. I want to be very clear. I file them all in good faith and only after conducting significant due diligence. I have never, ever filed a shakedown and not about to start. But there are many people out there who abuse the system because in bankruptcy, I can sue you for a 50-cent stamp, first-class mail. That's service of process across the world, across the country, in the United States. So if you're in the United States and Texas and you get a letter from a trustee in Delaware, you're going to hire a Delaware law firm, a Delaware expert, and you're going to make this argument, ordinary course of defense. That's the argument. Ordinary course of business, defense. The argument is that this is just like we did it all the time between the parties. And then if that didn't work because you got a wire transfer after sending an email threatening to send Vinny, and they get that, they're going to have the debtor's emails, by the way. They're going to have the emails where you said, I'm sending Vinny over with a sledgehammer, pay me or else. And then they pay you by wire transfer, although they've always paid you a check in the past. Okay, so these are the circumstances that make it look bad for you. Unusual debt collection practices, change the meaning. By the way, should you stop collecting a debt because you think someone's going to go bankrupt? Raise your hand if you think you should stop collecting aggressively when you think someone's in trouble. Okay, good. So we're all on the same page. Yes, you get the money and then worry about the preference. Okay, so payment in the ordinary course of the industry. This is very careful. You don't think you're trapped by the SIC and NICS codes that are on your tax returns. You can have an expert who will explain that's just for tax purposes. The SIC code that should apply to this is another guy, another number. The oil field is regularly late, and if you get the right NICS code, you can prove that in the industry, 120 days is not outside the ordinary course. Late, it's not a late payment. Hire an expert witness. Now here's the best part. So, had a case with 166 defendants, all being sued on preferences based on a data dump. The trustee got a spreadsheet of all the payments within 90 days and did a mail merge into a complaint and sued everyone, all 166. All right. If you had 166 lawyers and 166 experts and 166 local counsels, that is ridiculously expensive. What I think you should do, this is a very good practice pointer for you, and it's worth your price of admission today, is when you get sued for a preference, call a lawyer who's a bankruptcy lawyer, have them check the docket. There will be hundreds of these suits. They are not filed one at a time. Then call the other defendants and gang up and hire one big law firm to make one big argument with one big set of experts, and it's so much cheaper when you divide the legal bill by 150 than if you try to pay it all at once. You can hire big shot New York law firms, and they can do massive damage. And the trustee will, in this case, the trustee got zeroed out. He paid nothing to settle the case. All right. This is Zach's.
So just to give you an idea, we tracked down some fun language that we found when courts have ruled on what the heck is ordinary course of business. And I'm going to read these to you because this language is just, it's equally funny as it is helpful. So picture a big judge saying this. We should pause and consider carefully before further impairing a creditor whose confident, consistent, ordinary extension of trade credit has given the straitened debtor a fighting chance of sidestepping bankruptcy and continuing in business. Amen, right? Bankruptcy policy, as evidenced by the very existence of this ordinary course of business statute, is to promote such continuing relationships on level terms, relationships which, if encouraged, will often help businesses fend off an unwelcome voyage into the labyrinths of a bankruptcy. Sounds good to me. Let's go further. Only dealing so idiosyncratic as to fall outside the broad range. That broad range should be deemed extraordinary and therefore outside the scope of subsection B. Further, the statutory language should not be construed to place businessmen in a straitjacket. And as the court should not impose a single norm for credit transactions within the industry, the inquiry is whether a particular arrangement is so out of line with what others do that it cannot be said to have been made in the ordinary course. Okay, so what do we do now after we've looked at our defenses? Step 4, make an offer to settle or prepare for trial. Now, the debtor or trustee is something you should always know. The attorneys almost always take these lawsuits on a contingency fee. Hugh, is that in your experience?
Oh yeah, not just me. There's a guy I know who has a Porsche Cayenne Turbo, or Porsche Panamera Turbo, who bought it just on one series of preference cases alone. I mean, you can make millions, because who's going to pay to fly to Delaware or New York and hire New York lawyers and New York experts if you can settle it for what, 30 cents? By the way, it's not like you did anything wrong. You just got paid.
But you've never been part of one of these shakedowns, right?
I've never shook anyone down, but I have occasionally made a little bit of money on, you know, I got this nice suit in Singapore. But yeah, I will say, like, I represented the Bearing Point trustee, and we had 1,500 preference cases. Guess how many of those 1,500 preference cases we took to trial? Yeah, it's amazing. It's amazing. So, okay, back to you.
So, these cases, maybe I should have written 100, are settled 99% of the time. Okay? Why is that? It's so risky to go to trial for both sides. And expensive. Like, if it was filed in Delaware, you have to get Delaware local counsel. Delaware has a mandatory mediation rule. Let's just go through some of the other ones. There's very little case law on these defenses because no one goes to trial on this. All right? So the trustee attorneys are guaranteed to get paid with the settlement. Whatever percentage that they have negotiated with the trust or the debtor, they're getting paid that percentage. So they're going to want to settle. And plus, just to understand, you need a very large exposure for it to become economic to dig your heels in and fight one of these with an expert. If you want to prove what the ordinary course of business was in an industry, you have to go get a $40,000 or $50,000 expert. And that means whatever service you were providing was a line that created a situation where you will get gotten paid maybe $1 million within that 90-day window, or $2 million. And not every line of service or good that we provide is going to create that situation, period. So a very select few of us will even be in a situation where we have $2 million worth of exposure. Now, when something happens like that, it is economic to go down and dig your heels in and last a little bit longer. But again, if you're in Delaware, you had to get your local counsel. You're probably paying a Houston attorney like us or like Hugh or I. Delaware has a mandatory mediation rule. You have to go mediate in Delaware with your local counsel and probably with that expensive banker or whoever you just paid for.
All right, so this is, I told some people about this earlier, they didn't believe me. This is double black diamond, super secret stuff, and I don't want any of you to tell anybody this. So, I'm kidding. I know you tell everyone. You get on Facebook tonight, put it out there. Okay, so in the credit manual, it always says, file a proof of claim. Raise your hand if you file a proof of claim when a company goes bankrupt and owes you money. Yeah, everyone, right? Okay, well, if you, a smart move to do is to look at your own books. And before you file a proof of claim, look at two things. One, the debtor's schedules. Did the debtor schedule you as non-contingent, non-disputed, liquidated amount that they actually owe for the amount that you've invoiced, or close enough that you could live with it, so that it's already in the schedules that they'll pay you? Question one. Question two, did I get a heap of money in 90 days before bankruptcy? If you got a heap of money before 90 days of bankruptcy and you're looking at no real recovery on that unsecured claim, don't file a proof of claim. If you're based in Switzerland and some Ponzi schemer's put his money over there, don't file a proof of claim. If you're based in Singapore and you don't want to have to fly around the world to Delaware to have a hearing, don't file a proof of claim. If you file a proof of claim, you are voluntarily putting yourself in the claims allowance and disallowance process and voluntarily saying, I will go to that bankruptcy court wherever it is at any time. I will answer all discovery from the bankruptcy court, and I will be a party in the bankruptcy proceeding. I'm waiving my right to a jury trial, and I'm waiving my right to go to district court and have an Article III lifetime appointee judge who's a real judge, and by the way, a very busy one, hear my case. If you don't file a proof of claim under the Kansas Supreme Court case of Ground Financier versus Nordberg, and you are sued for a preference, remember what I told you earlier about courts of chancery in the 16th century. Courts in chancery in the 16th century, where their debt collection happened, had juries. You get a jury trial. Good luck telling a jury what you did wrong. I wouldn't do it. Tell the jury, what did he do wrong? Well, he got paid within 90 days on a legitimate debt. And we want the money back. And you sued him over this? If I'm a juror, I'm probably not going to rule with the trustee. The other thing is, this is in the district court. I'm sorry, but most district court judges look at, and I'm going to say something bad about bankruptcy lawyers. People think about bankruptcy lawyers like they think of divorce lawyers. And normally, getting like Rodney Dangerfield, we get no respect. So the bankruptcy issues that go in front of a district court are after every drug case, every immigration case, every Social Security case, every big civil case, patent case, trademark case, constitutional law case, habeas petition, and all of that other jazz. So you'll get a trial in never. Sometime between now and apocalypse. And so that's a great one. I've done jury demands and I've just sat, put my feet up. You move to withdraw the reference once you file your jury demand in the adversary proceeding in the bankruptcy court. Withdraw the reference to the district court, put your feet up, and let it cruise. They take discovery. Hey, I'm guilty of sin. I sent Vinny over. I got paid by a wire transfer. I was paid on a 1-year-old debt, which is outside the industry, and I'm guilty of sin. Yeah, I still want a trial. I don't think you get summary judgment that I have a preference. Because I have at least one guy who's going to say that this was ordinary in the industry, and so we have a dispute for a jury, right? Or I'm going to say it's ordinary between the parties, right? And there's a real dispute, and it goes to the district court. It takes forever, and now you have real leverage. Deposit checks quickly. Keep the envelopes to show postmarks. Oh, by the way, keep your delivery tickets too. Note the date of delivery of goods. Remember, it's not the date that the invoice is sent out, it's the date of delivery of goods. So you delivered the goods on the 91st date, you sent out the invoice on the 60th date, you didn't make a or the check came in on the 91st date and was deposited then, and it was cleared then, that's great. But the delivery of goods came in afterwards, or you have this preference issue when the delivery of goods is. Delivery of goods is something you need to know for the defense of both new value and whether or not there was a transfer. Did you change your coordinate? Okay, here's a question. I think I've already asked this. Do you tone down your collection practices because you know someone's going to file bankruptcy? Yes or no? No. Do you go COD? Yes or no? Yes. Do you perfect your PMSIs within 20 days? Yes, you're supposed to do that anyway.
Now, you go COD even though you know it's going to mess up your ordinary course of business argument later?
Yeah. I'd rather have the money because I don't know when you're going to file. There's this thing called forbearance. Okay? Forbearance is when the bank's banging on your door and they're about to file, and then at the moment, you know, I've had this happen to me. I've filed a lot of debtor cases, some oil field services cases. Hi, guys. And so when I filed those cases, inevitably, I thought the filing date was about a month or two before it actually filed. Because at the last minute, the bank said, okay, wait, we got this one more issue we want to try to work out with you. And we can get forbearance. And so forbearance frequently delays the bankruptcy. Even when you think it's going to file, you don't know when it's going to file. Okay. Perfect liens, all loans and liens, regardless of state law, within 10 days. That's just a bankruptcy thing. Okay, file a 503b9 administrative claim. All right, super special weirdness has happened in 2005. Here's what happened. People got tired of delivering goods and then turning around immediately and seeing the guy file bankruptcy. In fact, bankrupt debtors, and as a debtor's attorney, I sometimes saw this even advised to debtors, was order all the widgets and then we file. Like 10 truckloads of widgets come in and we file the next day. Because we know they'll cut us off, and so we want a big stockpile of widgets. There's a new provision in the Bankruptcy Code under Section 503b9 that gets you an administrative expense. That means paid. Gets you an administrative expense if the goods were delivered within 20 days. What if it was psychological counseling delivered within 20 days? Do I get an administrative expense? No, it's goods delivered. What if it was consulting services? No, only goods. What does goods mean? What does Article 2 say goods means? Okay. Here's a question. Should you cash a check that is clearly your preference? I've given you the answer. Because you're going to settle that at 50 cents on the dollar. So take it now, and 2 years later, maybe you pay some of it back. All right?
I mean, even the initial demand letters the trustees sent, they'll say, if you pay me 80% now, we'll walk away. I mean, that's probably the worst case scenario.
Right, yeah. If you're guilty of sin, the first demand letter to you will still offer a discount. Because I'm in it for contingency. Lawyers are in it for a contingency fee. And they would rather have the money quickly and now than have to work for it. So the first demand letter will try to get you to settle. Okay. Preference cases take a year or more before you have to pay and usually settle at 50% or less of the posting value demand number.
Okay, a few other things. For various reasons, whether it be because of the statutory elements they have to prove or because of our defenses, a couple of things to always remember. True prepayments are never preferences. That's because they're not on account of an antecedent debt. That's one of the elements the trustee has to prove. Now, make sure the check clears before you provide that good or service. Okay, don't take the check and then put it in your desk for 3 months and then provide the good or service. Okay, then it messes up the timeline here. If you pay a settlement amount in a preference case, technically you may file, according to the Bankruptcy Code, an unsecured proof of claim for that amount that you settled for. The idea being, I would have been able to file a proof of claim had I not been paid right before the bankruptcy got filed. Generally, when you settle these things, the trustee asks for a waiver of those rights, and we generally provide them, but sometimes those unsecured claims do get paid a portion, so we want to keep an eye on that. You will generally not be liable for trustees' attorney fees, but if they end up getting a judgment against you, you will be liable for interest, often. So you obviously have to pay your own attorney, but that's a different thing. You don't have to worry about the trustee's attorney fees. If you think you have preference exposure, keep a clean, clear record of payment history. So you could evaluate your ordinary course of business defense between the two parties. Invoice number, amount of payment, amount of invoice, payment amount, and payment clear date. Look for early opportunities in the bankruptcy to bargain for waiving a potential preference claim. We're not often successful, but every now and then, if there's a critical vendor motion out there, sometimes we could say, all right, we'll sign up to be critical vendor. We'll continue to extend good credit terms and work with you post-petition, but I want you to waive our preference liability, our preference exposure. we have been successful in that before. And then when you're in the thick of things, consider creative settlement arrangements. This could be a payment plan. This could be a forbearance to pay in exchange for an agreed judgment. Several other different things. Hugh, have you ever come up with something kind of wacky?
Oh, yeah. I love buying the claim against myself and buying all the other preference claims. You could do that, and then you get to drive the Ferrari. All right. I've left some time at the end for questions because this is this preference defense is one of the most bizarre and counterintuitive things we do in bankruptcy. So who has a question? And remember, there's no such thing as a question I will actually answer. I could tell you stories. Some of them are out of the ordinary, but one of the weirder things that's happened in the course of defending against preferences that I have when I talk with people in India, China, Japan, is explaining to them that you've done absolutely nothing wrong. That is a hard fact to internalize. It's hard for small businesses to get. And it's harder for big businesses abroad to get, that you've been sued when you did nothing that you weren't supposed to do. You were just supposed to do it. I mean, a capitalist society, you're supposed to get paid. So I think if it's a credit management issue and you're working for a company and a preference issue comes up, you might want to consider how you deal with that internally. To explain that we've been sued for $2 million and we did absolutely nothing wrong. And they'll admit that. The other side would say that. Come on, have you thought of any cool questions? I can tell you about the guy who drives the 3 Ferraris, but I don't want to tell you who he is. But, yeah.
How does the statutory 180-day lien bar date factor into defining ordinary course when the statute says it's 180 days?
Right. There's 2 issues there. The first is what is happening in the oil business, which is that we don't have to get paid right now, because I know I got a lien for it, right? So I'll be out 120. So the ordinary course in the industry in the oil patch, as opposed to delivery to, I don't know, perishable goods or computers. Computers is net 15, right? So, oil patch is a little more flexible. But the other thing of that is, remember, one of the elements that you have that's not yours to prove, one of the elements that poor bankruptcy trustee, that poor defenseless bankruptcy trustee has to prove, is that you received more, than you would have in a Chapter 7 liquidation, in a hypothetical Chapter 7 case. And what would have happened if you had not, and the payment had not been made, right? So if you had not been paid, you would have filed a lien, they would have filed Chapter 7, and you would have been leaning up the wells, and you would have been paid, right? So I don't wait for the defense. I go on the offense, on the first end, because that's really your strongest element. He has to prove that. And you have an argument, and he has what? It's his burden of proof. So that's the best defense. Now, having said that, if you get a letter from me asking you to pay a preference, please do. Yes?
You do a service on a well, or you're putting chemicals or acids down or something like that. Is that a service or goods?
Parts of it are going to be goods. Parts of it are going to be services, right? And I'll tell you the truth, and then I'll tell you what you should do. Okay. So the truth is, you take the invoice will have portions of it that are like acid treatment or hot oil job or something like that. There's going to be oil provided by pumping it in and taking out the paraffin, something like that. So that's a good. The oil's a good. And then there's a service component to it, right? Now, truth is, these guys in New York and Delaware don't know that. As far as they're concerned, you delivered oil, hot oil to a well. So I would stick with saying it's a 503b9 claim and see if they ever read it. And if they do, then say, then I'll divvy it up. But I wouldn't start with doing their work for them. Especially, now wait, if you're in Houston, you might have frankly, you'll have savvy people that'll read it and say, oh, come on. only part of that counts. It depends on who's in charge of that. But you'd be surprised what you can find in these large gazillion-dollar cases all over the place. Got another question? No? Okay, who's hungry? Okay, wait, I got one more over here. Yeah.
The toughest, most bitter preference claim is when you got paid and then all of the open creditors, they get paid. But I don't have any open invoices because I got paid 2 weeks before they filed.
Yes?
Now I've got a preference claim, and if I would have just not got paid, I would have got paid.
Well, probably only pennies on the dollar, right? Yes, but I get your point.
Needs to be an argument for that.
Well, that's part of the weird math, and I'll give you an example. In a case where there was like one giant preference, like a $2 million preference, and then all the other unsecured creditors are worth $200,000, that ability to file a claim for the amount you pay in settlement of a preference really becomes meaningful. Because you pay the $2 million back, but now it's $2.2 million. I'm getting 90% of my money back through the waterfall. Oh, no, you're not. Because who's going to take 33% of the recovery before it goes to the estate?
The guy with the Ferrari.
Yes! Yes! That is exactly right. So, the math theoretically works that way, but in reality it doesn't.
And I think, because I know the case that Doug is referring to, what has gotten particularly frustrating nowadays is we're seeing a trend where there's motions to pay lien creditors or motions to pay certain creditors just at the debtor's discretion. And so, at the end of the day, lien creditors get paid however the debtor has determined those creditors will get paid, be they critical or not. And then at the end of the day, companies that, like the one that Doug works for, gets sued on a preference exposure because he received the payment prior to the bankruptcy filing. If he just wouldn't have received that payment, he probably would have gotten paid pursuant to a very arbitrary lien payment order,
Right.
Because the debtor had the discretion to do that.
Right, and he would have filed a post-bankruptcy statutory lien perfection, and they would have had to clear it.
Except in some cases, as we've mentioned off and on today, all of a sudden we notice that there's a lien waiver in their MSA.
And whether that's effective or not is a matter of some dispute,
Right.
as we know that's come up. Yes?
In the bankruptcy situations that occurred over the last few years, the restructuring officers that came in and took over the financial position of these companies, did they know, they fully were aware of the preference claim situation, and they had used that tool
Deliberately.
deliberately.
Yes, absolutely.
because
They prefer
to
you
hold-
to get screwed later.
Yeah, to hold you off, like kind of
But-
situation where we were on the verge of filing liens,
Right.
and they opted, well, hey, we'll pay you, and then, but don't file your liens, and then, so
Right.
you don't secure
Right.
yourself up.
You gotta, there's an Ed Rothberg's in the back.
Then coming through the back door and
Yeah.
getting on.
Ed taught me to play the chess game forward. And if you're playing several moves of chess ahead, what you're thinking is, I need people to vote on my plan of reorganization, or I need to have a realistic recovery on the back end of this case for the lien holders or whatever. I need to give some give at the end to get this case confirmed. So if I make a bunch of preferences and then I take all the preference claims of X million dollars and then I put them in a trust at the end of the case, I can have something to sell to the people who are voting for the plan of reorganization. So sometimes, if you're thinking several steps ahead, you deliberately manufacture a preference so that you'll have an asset for the liquidating trust. That's devious and evil and mischievous, and who on earth would be that horrible a person to think
Exactly
of
what they did, though, all of them.
that? Yeah, we all do that. Okay, so then wait. It gets better. It gets better because you can do the opposite chess game. So you're involved and you got paid, but not in full, and you're an unsecured creditor. What do? There's another session later on today about creditor committees. And I said gang up. It's absolutely possible. You go gang up. You tell the debtor, I don't want you. And I had a recent case, I did this. As committee counsel, you're not going to sue anyone for preferences. You don't have that power. They're gone. They're waived. We don't want to be bothered. And it's not gonna come, the money's not gonna come back to us. We're gonna share pro rata with a $100 million deficiency judgment? I'm never gonna see that money, and 33% of it's gonna go to a lawyer. A stinking lawyer. All right, guys. I know that there's food out there, and if you're hungry, let's go eat it. I do.